qualified. And when I looked at the scoping that was done for a person who can qualify for that office, I thought I met the conditions, and in the circumstances I applied. So, Chair and Commissioners, I'm here very humbly seeking that I be evaluated on my competence to be appointed. And the fact that I may have recently been before you should not be a factor, because I'm not here for a promotion. I'm here for whether I'm competent. I also observed that quite a number of people have come to the Supreme Court directly from outside judiciary. And so judiciary is not necessarily a stepping stone for qualification to qualify for that office. Those are the considerations that were in my mind, Chair and Commissioners. And I say this with the greatest humility.
Very well. Now, then we can come back and forth to that question of, are you happy in the Court of Appeal? Are you satisfied with being a judge in the Court of Appeal?
I am, my lady and commissioners, and thank you very much for having found me deserving to take up that office. I want to express my gratitude to all of you. Yes.
Yes. So now, we want to hear from you why you think this commission should recommend you for nomination of the office of a judge of the Supreme Court. We want to hear what experiences and skills and knowledge you will bring to this court, and how you're going to leverage them or to locate these skills within the 5 or so jurisdictions of the Supreme Court.
Thank you, Chair and Commissioners. I consider myself eligible for consideration to the office of Supreme Court Judge on the premises that, in my estimation, I have a feel and experience of all facets of Kenyan, both as a Kenyan citizen and also my competence in legal practice. I grew up in an environment where, in an environment of want, I went to Kiplombe Primary School, I went to Mother of Apostles Seminary, I then went to St. Patrick's High School, then came to Nairobi University, and through all those levels, it was hard work, enterprise, and studies that took me through all that. I then entered into legal profession now for about 30 years, and I have both national and international experiences. I have represented all cadres of people. I have gone to all legal forums and even non-legal forums, and the wealth of all those experiences, my lady and commissioners, are such that I would contend that makes me very qualified for this. A little more on the issues of where I've appeared. I appeared in tribunals, I appeared before commissions, I appeared before magistrates all the way to the Supreme Court. I have represented judges, I have represented advocates, I have represented other people. I mentioned particularly representing advocates and judges just to make the point that those are the best judges of my competence, and if in their evaluation they thought I could represent them, then it is a strong statement of my competence. I think the type of works I have done, the results I have produced, are such that they also strongly comment on my competence. I will not pretend to know all the law, both in terms of statutes or precedents. I will not pretend. But what I can say for a fact is that I have the competence to identify what the issues are, to be able to analyze them, to be able to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes on sports law. And the legal regime, I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Ishale will take it from here.
Thank you, Honorable Chief Justice. Judge Keegan, there are concerns expressed by a section of Kenyans,
yes,
as regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as the Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you're successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is, well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who applied to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petitions. There are other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important, it's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So, recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, but I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law, and I want to quote what he says: "Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history? I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be,
Yes.
How did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail, keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the two drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, okay, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract, that you have to have a relationship with the person you are suing. But then the consequence of that case was that if you are offering a product, it should be probably in more developed law now, consumer rights. If your items cause damage or injury to somebody else, the fact of lack of privity of contract is not a defense to your liability for what you're offering to third parties.
So that is a law after 1928, but before 1928, you had to establish that there was privity of contract. Now, coming back home to the Supreme Court, what are some of the notable jurisprudential decisions that you can say have impacted our lives?
How many, my lady?
Pardon?
How many?
Give me 4.
Okay. So I think the most remarkable ones for me are 2. The first one is BBI. And the issues then were whether in the name of amendment, the executive could torpedo the Constitution, could replace the Constitution in the name of amendment. And I thought judiciary came out very proudly there to firmly put down their foot and say, we can only change the Constitution using what is there. And I thought that was a very momentous.
So that is one.
Yes,
one.
2.
Yes.
Is the 2017 elections, August 2017 elections, where the judiciary distinguished itself in refusing to recognize the presidential elections. I did not and do not agree with the reasoning of the court then, but I thought even then we shouldn't miss the point of the independence of the judiciary in making that decision. I thought it was a very momentous and strong statement of the independence of judiciary.
I agree with you.
Yes.
Number 3.
The third one from the Supreme Court would be the finance bill. For quite some time, I know there has been pull and push between the executive and judiciary, and it entails questions of whether the judiciary is being activist, is overreaching, and is micromanaging the executive. The concept developed in that finance bill, suspension of declaration of invalidity, is a very important measure, because then it gives the executive time to adjust itself to the requirements of the circumstances of the situation.
All right, and finally, the fourth one?
The fourth one is the Muruwatetu one. Of course, it is very controversial, but then the determination that there has to be a distinction between the roles of the executive and the judiciary and the executive, the separation of powers, was to me a very important.
Was that in Muruwatetu 1 or Muruwatetu 2?
In actually both, because in one, the decision I thought was a general statement that the judiciary should not seem to determine the sentence.
All right.
Should not tie it. But then in the Muruwatetu 2, then the Supreme Court came back and said our intention was only limited to murder.
All right.
I think, yeah.
So it is like the issue of discretion, mandatory sentences.
Yes.
The executive should not interfere, but it should be left to the judiciary. Yes. Thank you. That's all, Honorable Chief Justice.
Thank you, Commissioner Mwansa.
Thank you, CJ. Good afternoon, Judge, again.
Good afternoon, Commissioner.
Judge, Article 19 of the Constitution is the article that starts with the rights and fundamental freedoms.
I'm allowed to refer?
Yes. And now, Article 19.3 provides that the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. Then Article 19.3b provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with the chapter. And 3 provides that those rights are subject only to the limitations contemplated by the Constitution. Now, in developing that issue, we have what we call enumerated and unenumerated rights. And it could seem that what Article 19.3b states or provides for are what we would refer to as unenumerated rights. Now, while enumerated rights are clearly written, the unenumerated ones are inferred. So that the concept is that there is a limited list of rights in a constitution that does not mean that fundamental rights do not exist. So the first question is as follows. Are there rights that you would say that are fundamental and are not contained in Chapter 4 of the Bill of Rights, but they are unenumerated and you can infer them? And if so, if you probably can list maybe 4 or 5.
Okay. Commissioner, I'm not sure I know I have an answer to the point you made about the enumeration. I'm not aware whether there is anywhere where they are listed, other than in the Constitution, of course, which I'm aware of, but I don't know whether there is somewhere else tabulated. Commissioners, I will pray to probably refer to the experiences I have. Some of the rights that I know are internationally recognized but are not captured in the Constitution is, for instance, against genocide. I I'm fairly sure it is not in the Constitution, in the words genocide. I know there are issues of human dignity, human rights, against servitude and all that. But I think genocide as a crime is not there. And I'm borrowing from the International Criminal, the ICC statute. And I'm referring to the ICC Act because Kenya is a signatory, which in effect then, and most of the world countries are signatories, which then means it is a recognized right. So genocide, war crimes, acts of aggression. Others that come to my mind, and they do not necessarily even relate to Kenya, is apartheid. I think there is generally condemnation of conduct that amounts to apartheid, and I think that could be one of the rights that you could incorporate there. The upheavals in West Africa resulted also in warrants and summons on issues of damage to World Heritage Sites. And so I think UNESCO protected locations, or rather damage to World Heritage locations are also a crime. Commissioner, I hope I've managed to make 5. I'm not sure if I have.
Okay. Now I want to go to Article 45 just to explore that topic.
Yes.
So Article 45 of the Constitution provides that the family is the natural and fundamental unit of the society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. And more importantly, Article 45 2 provides that every adult has a right to marry a person of the opposite sex on free consent of the parties. Now, when you read Article 27 on equality and freedom from discrimination, this is now the equality clause. It provides that every person is equal before the law and has a right and equal protection and equal benefit of the law. And then there is another important article, (27)(4) provides that the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, belief, culture, dress, or language. Now, this article in the first draft of the Constitution actually provided for discrimination against sexual orientation. But subsequently, in the discussions that followed, and now, when you read Article 2(6) of the Constitution, it provides that any treaty or convention ratified by Kenya shall form part of Kenyan law under this Constitution. So I wanted to ask a question using that context. Now, Article 16 of CEDAW, the Convention Against Discrimination of Women, provides, and the definition in Article 16 of CEDAW is different from the one that is found in 45. So the question is, if a party comes to court and pursues an argument that that article would allow maybe a same-sex marriage because it's a convention that forms part of Kenyan law, what would your view be about it? And would that be then what we started developing about an unenumerated right?
I can answer?
Yes.
Okay. So first of all, let me just add one more in the list I've given. I've just remembered in the course of you inviting me to Article 45, I have remembered that Kenya now acknowledges for a fact that intersex people are entitled to rights.
Yes.
And that's not one of the rights of intersex and transgender. And I thought, even to the extent it is not enumerated, it is a consideration. I'm just concerned at what it says in 19.3b, that to the extent that it is not inconsistent with this chapter 4. Now, just on that issue of transgender and intersex still, I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45.2, I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45.2 says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? Have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45.2? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45.2 saying the limit of people who can marry each other are of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45.2, being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45.2. 45.1, 1 and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution allows a family constituted of people of same gender. Of course, I'm very much alive that I am a candidate. I know it's a very unpopular argument, but I'm just making it as a legal argument. I'm not making it as a question of my position. I need to clarify that. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner.
Okay.
The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes, yes. So I tried to set the context because there are sometimes there are hard questions that are presented before the court and that the court should answer. Now I want you to take to Article 49 on freedom and security of a person.
Yes.
So Article 49 provides that every person has the right to freedom and security of the person, which includes the right not to be, and for purposes of my question, is D, subjected to torture in any manner, whether physical or psychological. So, physical torture is fairly, something, it's discernible.
Yes.
But psychological torture might not be, immediately discernible. So you have, and this possibly we practice it when we were younger, where we were, as children, we did not have a choice to the oath of allegiance. I pledge my allegiance to the President and the Republic of Kenya. You remember that?
Yes.
Or salutation of the flag.
Yes.
Now, would you say that forcing children, to do oaths of allegiance or to salute to the flag, without having the choice on participating in those activities, would amount to being subjected to torture, whether physical or psychological? Because it's not a choice that you have, particularly if you're in school. I don't know whether it happens right now, where you are told, salute to the flag, or it's at 6 p.m. the flag is about to be lowered. Stand up and be at attention, or do the loyalty pledge.
Okay, so can I answer?
Yes.
Yes, my answer would be, I understand your question to be particularly in respect to the flag. You didn't say what flag, but I assume it would be the national flag.
Yes.
You also said pledge. I assume it is pledged to the country rather than to an individual or to any religion. To the extent, therefore, that you are dealing with national symbols and national concern, I would think it is more of patriotism than a question of torture. That's one. Number two, I would say, since your question is very carefully cross-referenced with children, that children being people who are being molded, it is right that they should be subjected to develop a sense of patriotism and loyalty, and I wouldn't see anything wrong in subjecting the children to appreciate the importance of patriotism and loyalty as they grow. And lastly, you tie your question with the question of torture, both physical and psychological. My understanding would be that torture is a relevant part if you intend to extract something out of it. In the situation of the children, I think it's just teaching them where priority, where importance, where where values exist. It wouldn't seem to me like anything is being extorted out of the children. They are not being asked to make any confession. They are not being asked to sign off any rights. They are not being asked to surrender anything or to give anything. And to the extent, therefore, that it is part of education and development of the children, I would contend that it is a legitimate conduct.
Okay. And lastly, if you look at Section 3 of the Supreme Court Act, provides for the object of the Act and makes further provisions with respect to the operation of the Supreme Court and its final judicial authority. And one of the guiding principles under 3 is that the court should develop rich jurisprudence that respects Kenyan history, traditions, and facilitates its socio-economic and political growth. Are you aware of instances whereby either the Supreme Court has developed the common law, or it has infused these constitutional principles and created sort of a Kenyan context interpretation of the law? And I get this from what Justice Mutunga used to say, that we should develop jurisprudence that is indigenous.
Okay, so I will answer the question in terms of what indigenous jurisprudence and principles of law have been developed by Kenya, and with reference to your question, particularly by the Supreme Court. I think in the recent past, the Supreme Court has made a determination on the question of matrimonial property. And in it, I think it is an indigenous contention that contribution for purposes of the rights of a spouse can be gauged, not limitedly to financial contribution. It could very well be in kind, family upkeep, taking care of the children. And I think that's an indigenous contention, that contribution is not limited to financial contribution. I think that one. The other one, although I can't say for us absolutely that it is, it has been determined by the Supreme Court, I think is the issue of trust on land, being that where you have a family member being registered in the course of adjudication and other types of registration, being registered as the owner of the land, it shouldn't be perceived as if that is the only owner of the land. It should be treated as a trust on behalf of the family, on behalf of the other family members, and that it is being held by the person whose name is registered in trust for the rest. The other one is probably also trust in relation to matrimonial property, that where you have one spouse's name
Shukrani mtazamaji kwa kujiunga nasi siku hii ya leo kutoka Mahakama ya Milimani, ambapo msasa wa majaji wa Mahakama ya Upeo unaendelea. Umekuwa ukitazama moja kwa moja. Turejea hapa studioni nikujuza yale ambayo tumekuandalia siku hii ya leo kwenye Undugu wa Dhuhuri. Niite Sebastian Maria, mwelekezi wangu akiwa ni Dominic Chero. Tuna baada ya taarifa zetu, basi mtazamaji, tutakuwa tunakurejesha moja kwa moja huko kwenye Mahakama ya Milimani ili uweze kuendelea kutazama. Karibu nikujuze. Tume ya huduma ya idara ya mahakama imeanza kuwahoji wawaniaji wanaolenga kujaza nafasi iliyoachwa wazi na aliyekuwa jaji wa Mahakama ya Upeo Mohamed Ibrahim aliaga dunia. Wa kwanza kuhojiwa alikuwa Anne Wasike Makori, aliyekuwa mwenyekiti wa mamlaka ya IPOA na wakili wa miaka mingi. Wasike akikabiliwa na masuala magumu kuhusu ufahamu wake wa masuala ya kisheria, kama vile sababu za kuanzishwa kwa Mahakama ya Upeo nchini. Kwa sasa anahojiwa na jaji wa Mahakama ya Rufaa na aliyekuwa wakili wa Rais William Ruto Joseph Katwa Kigeni. Tutazame. Na Rais William Ruto ametoa wito kwa mataifa ya Afrika kushirikiana kuhakikisha rasilimali zilizopo zinatumika ifaavyo kwa manufaa ya mataifa hayo. Akizungumza jijini Nairobi wakati wa mkutano uliowaleta pamoja wadau mbalimbali katika sekta ya madini na uwekezaji, Rais Ruto amewataka Waafrika kuamini kuwa bara la Afrika lina uwezo wa kuafikia mambo makuu, akiwatahadharisha dhidi ya kueneza mabaya kama yaliyoenezwa alipotangaza ushirikiano wa Kenya, Uganda na Tanzania kukuza kiwanda cha mafuta.
For example, let's talk about 6,000 you get 6 carats stone.
We had a meeting last week where we were discussing how Kenya, Uganda, Tanzania, as states, can invest in a joint refinery that will refine the oil resources that we have in this region. The oil resources we have in Uganda, a bit in Kenya, in South Sudan, and our region. When you read the headline on the East African, it says, Uganda's headache. There was no headache. For heaven's sake, there was no headache. I mean, how does 3 countries coming together to build one piece of infrastructure that supports the region, how does that amount to a headache? So I really want to persuade us, as you sit here, let us believe in ourselves. Let us believe in our continent. And I always urge people in Kenya, let us believe in our country. Let us profile it positively. Let us work together so that we can harness the full potential of who we are, the resources that we have, and the opportunities that are there for the benefit of everybody. And that would really help us make much more progress.
Tuelekee kaunti ya Embu ambapo baadhi ya wakazi wa Mahakama kaunti ya Embu wamejitokeza na kuweka bayana kuwa wataunga mkono serikali ya kitaifa ili waweze kupata maendeleo katika eneo lao. Wakazi hao wamesema kuwa kwa muda mrefu wamekuwa wakiunga upande wa upinzani, jambo ambalo limefanya eneo hilo kuachwa nyuma kimaendeleo.
Atua mbele.
Come together as people of like minds from Mahakama because of the desperate state in Mahakama ward in terms of development. We have been lagging behind. This community is really struggling, and we are associating all this to the bullying of government elected officials by the people who are affiliated to the opposition. Today, we have come forward with nobody who has sent us, but we have called ourselves for a meeting, and we have analyzed all the situations. We have found that in Mahakama ward, we don't have good roads. We don't have a single kilometer of tarmac road. We don't have water, enough safe and clean water for our people. The schools are in desperate state. We don't have enough teachers. We don't have enough doctors in the hospitals within our ward. And today, we want to promise the government of Kenya, the government of Cicely Mbarire, our governor in Embu County, our MP, that we are going to work hand in hand with you so that we can see the development which are in their need in this community.
Kukosa maendeleo yetu ni kukua sisi tumeishi katika opposition miaka yetu yote, na sasa after kurealize sisi kama wakaaji wa Mahakama tumejitokeza bila kutumwa na mtu yeyote, tuitishe maendeleo yetu na tuunganike pamoja na serikali yetu. Juu tumekuja kuona sisi wenyewe tunaendelea kuteseka, tunaendelea kuachiliwa nyuma kwa sababu sisi hatujawahi unganika na serikali yetu. Sasa hivi sisi tuko tayari kufanya kazi pamoja nao.
And come to knock the door to the government, for the government to listen to us. We are not here to complain. We are not complaining, but we are here to raise our voice and to have our voice listened to.
Naam, kiongozi wa chama cha NLP Dr. Augustus Muli amemkosoa vikali aliyekuwa naibu wa rais Rigathi Gachagua akimtuhumu kwa kuwa na msimamo usio dhabiti katika siasa za eneo la Ukambani. Dr. Muli amebaini kuwa ni kinaya kwa Gachagua kuunga mkono viongozi kutoka eneo la Ukambani, ili hali alipokuwa naibu wa rais alikuwa akiwapinga na kuzuia maendeleo kufikia eneo hilo.
This is the question we are raising now. So, nakumbuka very clearly 3 years ago. 3 years ago, not very long. When Mheshimiwa Gachagua used to go around Ukambani, alikuwa anasema viongozi wenu ndio wamefanya hivi, waliingia hawakuwasaidia. Simsikia hiyo? Hao viongozi ambao alisema hawatusaidii, sasa ndio anasema they are the best. The same leaders 3 years ago, 3-4 years ago, alisimama akasema hao viongozi ndio wamefanya Ukambani tuangamie kwa shida. Saa hii yeye mwenyewe anazunguka anasema these are the best leaders for this country. What is he saying? Anasema sisi Wakamba tupatiwe wale viongozi wabaya ndio tuendelee kukaa na umaskini, tuendelee kukaa na njaa. It is time we said no as a community. It is time we said no to bad leadership. Kila mtu ambaye amekuwa kwa uongozi in this community for over 20-15 years, 40 years should go now.
True.
They must agree. They must admit that they have failed this community. They do not deserve a second chance. Wewe umekuwa kwa uongozi na community imeendelea kudidimia, community imeendelea kuwa na njaa na shida, na bado unataka chance nyingine ya kufanya nini? Tumekataa. Sisi kama National Liberal Party tunasema tumechoka. We want development. We want factories. Anybody talking factories, tutamshika mkono. The first person atatuinulia Kitui Ginaries, tutamshika mkono. The first person ataturudishia BAT tena hapa, kampuni ya tobacco, tutamshika mkono. Tutengenezeni kampuni, watu wafanye kazi. These are educated people, but they need opportunities to better their lives. Sio mkuje mtununue. Nafikiri pesa zetu zitatupeleka wapi? Your money will feed us today and tomorrow, but not my children. Yes. So tunataka factories, tunataka industries, so that our people can develop our people.
Na kesi ya kutimuliwa kutoka ofisini kwake aliyekuwa naibu wa rais Rigathi Gachagua ilianza hapo jana, ambapo mahakama inatarajiwa kusikiza kesi ile tena tarehe 7 na 8 mwezi wa 5 mwaka huu. Gachagua aliitaka mahakama kutupilia mbali ombi lake la kuomba kurejeshwa ofisini, japo akitaka koti itangaze kuwa alitimuliwa kinyume cha sheria. Pia wakiambia mahakama kuwa taratibu zilizotumiwa kumtimua Gachagua ziliharakishwa kiwango cha kuwa hakupewa muda wa kujitetea hata baada yake kulazwa hospitalini.
Mahakama Kuu ya Nairobi imerejelea kusikiza kesi ya aliyekuwa naibu wa rais Rigathi Gachagua. Mchana wa leo mawakili wa Gachagua wamejizatiti kuirai mahakama kutangaza kuwa taratibu zilizofuatwa kumtimua Gachagua zilikuwa kinyume cha sheria. Kwenye ombi lake, Gachagua pia ameitaka mahakama kutupilia mbali ombi lake la kurejeshwa ofisini, ila akitaka afidiwe na alipe marupurupu ya naibu wa rais.
His Excellency Rigathi Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition he abandoned the prayer for reinstatement. I wish again, my lords, your leadership, to reiterate that position on record.
Mawakili wale wakiongozwa na Paul Mwite wameiambia mahakama kuwa mteja wao hakupewa muda unaofaa wa kujitetea, kwani hata wakati mmoja alilazwa hospitalini.
Here, falling ill on the second day of a grueling 2-day hearing, the Deputy President sought a 3-working day adjournment to Tuesday, 22nd October, to enable him to recover and appear for cross-examination. The Senate defeated that proposal to adjourn until Saturday to see if the Deputy President had recovered. Egged on by the National Assembly, the Senate insisted on proceeding in the Deputy President's absence.
Pia wametilia shaka jinsi maoni ya Wakenya ilivyochukuliwa kuhusiana na swala la kutimuliwa kwa Gachagua, wakisema Wakenya hawakupata nafasi murwa. Aidha, wamesikitika kuwa mteja wao alitimuliwa kwa mwendo wa umeme, wakisisitiza kuwa mchakato huo wote uliharakishwa.
Senate, as senior counsel here said, worked with ungodly speed in impeaching the first petitioner before you here this afternoon.
It's our submission that such an important exercise to remove the Deputy President from office, who was elected by the majority of Kenyan in each gazetted polling station in the country, required a similar methodology and participation to remove him from office.
Baada ya kesi ile kusikizwa mchana wa leo, vikao vingine vitarejelewa tena tarehe 7 na 8 mwezi ujao.
Tukiachana hayo ni kwamba walimu wa shule za sekondari msingi na wale wa nyanjani chini ya muungano wa KUPPET tawi la Machakos, Embu na Kajiado wameandaa maandamano ya amani, wakiapa kuwa kamwe hawatarejea kazini iwapo serikali haitaangazia malalamishi yao. Kati ya malalamishi wanayoelekeza ni kuwa kwa serikali ni pamoja na kupata ajira ya kudumu, ambapo wamebaini kuwa mishahara wanayopata wa shilingi 17,000 hautoshi na wamekuwa wakibaguliwa katika mfumo wa matibabu wa SHA. Wametishia kuelekea mahakamani iwapo serikali haitashughulikia maslahi yao.
Shule zinapofunguliwa kwa muhula wa pili wiki hii, walimu wa shule za sekondari msingi na wale wa nyanjani chini ya muungano wa KUPPET tawi la Machakos, Embu na Kajiado wameandaa maandamano ya amani, wakiapa kamwe hawatarejea kazini iwapo serikali haitaangazia malalamishi yao.
Wale ambao wako shule sasa, pole sana, kwa sababu sasa ni kama mtafunzwa na ulimwengu. Maana sisi mtatuona class ile siku tutakonfirmiwa tupewe kazi ya kudumu, sio kandarasi. Maana sisi tumehitimu, tumegraduate, tumeenda shule na tumesoma.
Walimu wameajiriwa 46,000 miaka iliyopita. Sasa hivi tunaleta idadi ambayo iko chini, only 44,000. Tunaomba wabunge wetu waketi allocate funds to our Teacher Service Commission so that they confirm the 44,000.
We have confirmation. We have a magic number. We are telling the government, we are wanting the government to confirm 44,000 intern teachers.
Walimu hao waliojawa na ghadhabu walibaini kuwa serikali imekuwa ikiwabagua chini ya mfumo wa matibabu wa SHA, wakisema wenzao ambao wamefanya kazi kwa muda wanapata manufaa ya bima hii ila wao hawapati.
SHA is giving teachers who are chief principals D1, D2, D3 300,000 for maternity. Hawa ni wale walimu wamesha malizana na uzazi. They don't have children, while the young teachers at C2, C3, C4 are given 10 to 30,000.
Walilalamikia hatua ya serikali kusita kuwapa ajira ya kudumu kila mara wanaposhinikiza kuipata, na mshahara wa shilingi 17,000 wanaopata uwezi mudu mahitaji yao.
Tunataka kupewa ajira ya kudumu. Tumechoka kuhudumia wanafunzi wa junior katika mkataba wa kandarasi. Hatutaki kandarasi, we are qualified teachers, tunataka kuajiriwa. Tumechoka kuteseka, mwalimu amekandamizwa na jamii, kila mmoja anajua kwamba tunapata 17,000.
Serikali haitilii mambo hayo maanani. Kwa hivyo tuko hapa kwa niaba ya walimu na kuungana na wao na kusema kwamba walimu wote lazima waajiriwe kwa kandarasi ya kudumu. KUPPET power!
Hata hivyo wametishia kuelekea mahakamani ikiwa serikali itaendelea kuwapuzilia.
We are requesting the government of the day that since already the court of appeal has only confirmed that internship in Kenya is illegal, we are requesting to confirm the intern teachers in the Kenya. We have no any other demand. And if you don't go by that, we'll use all avenue available to ensure that all interns in Kenya are confirmed. We don't go back to court.
Isaac Musioka, Undugu TV.
Naam, sekta ya utalii nchini inaendelea kuimarika huku bandari ya Mombasa ikipokea meli yake ya 5 tangu shughuli hizo zianze tena mwezi Novemba, jambo linaloashiria kuongezeka kwa imani ya wasafiri kwa Kenya kama kivutio kinachopendelewa cha utalii. MV Azamara kutoka Ushelisheli ilitia nanga bandarini Mombasa ikiwa na watalii 630 na wafanyikazi 389. Meli hiyo inatarajiwa kusalia nchini kwa siku 2 kabla ya kuelekea Zanzibar.
Kuongezeka kwa idadi ya meli za kitalii kunatarajiwa kusaidia Kenya kufikia lengo lake la kuvutia watalii milioni 5 wa kimataifa ifikapo mwaka 2027. Hadi kufikia sasa, bandari ya Mombasa imepokea zaidi ya meli 5 za kitalii katika siku za hivi karibuni. Miongoni mwa meli hizo ni MV Azamara kutoka Ushelisheli iliyotia nanga ikiwa na watalii 630.
Meli imetoka ng'ambo, imekuja hapa na zaidi ya wageni 650. Na hii ni ishara ya kuonyesha Kenya iko amani.
Akizungumza wakati wa kupokea meli hiyo, naibu mwenyekiti wa kamati ya bunge la kitaifa kuhusu masuala ya ughaibuni na uhamiaji, Simon Kingara, alisema kuwa ongezeko hilo linaonyesha kuwa Kenya ni nchi salama na yenye utulivu na kwamba iko tayari kupokea meli zaidi za kitalii.
Kenya kama pahali patulivu, wanaweza kuja kupumzika na vile vile kuangalia vile inafanyika hapa Afrika. Wamechagua Kenya na wakitoka hapa wanaenda Zanzibar. Kile la muhimu sana ni usalama. Vile vile Kenya sasa tumefungua Lamu, na kwa hivyo meli kutoka hapa meli kutoka Lamu sasa tumepata nafasi kubwa ya meli kubwa kama Lamu. Ukiangalia iko 17 meters down, hata ile meli kubwa kama ile inaitwa Elizabeth inaweza dock huko. Kwa hivyo naomba wageni wengi watembea Kenya kwa sababu sasa tuko na poti ya Lamu na vile vile hapa tuko na poti ya Mombasa.
Wito umetolewa wa kuongeza juhudi za kuboresha vivutio vya utalii pamoja na kurahisisha utoaji wa vitambulisho kwa mabaharia ili kufungua fursa za ajira kimataifa katika sekta ya bahari pamoja na kushughulikia changamoto zinazowaathiri watalii, hasa suala la kutozwa ada mara 2 katika maeneo ya vivutio.
We need to increase more attraction centers, and we also need to do some amendment in the policies we have. Like today, when we have visitors who have docked here, when they want to go out so that maybe they can go to Fort Jesus and other attraction centers, they have to pay some amount. When they get back here, then they have to pay again. And we've been talking about that policy so that we can amend it. So if a tourist pays once, he doesn't pay any other time. If he comes here, he docks, he pays once, then he doesn't have to pay any time. Because if you do that, then we'll enable them to come out to go to other attraction center so that at least their currencies can be used here in our county of Mombasa and any other areas in the jurisdiction of our country. The employment issue, we need to have the bilateral relationship between our country and other jurisdictions so that we entice them to be coming to our country and also to employ our youth who are doing the hospitality, the issue of working in the cruise ship, that is very paramount.
Sebastian Maria, Undugu TV.
Na kwingineko ni kwamba viongozi wa chama cha ODM wanaoegemea upande wa Seneta Oburu Oginga wameshikilia kuwa sharti chama hicho kifanye mazungumzo ya ushirikiano na chama tawala cha UDA, wakiwapuuza wenzao walinda mwananchi wanaopinga mazungumzo hayo. Wakizungumza katika mkutano na wenyeji wa kaunti ya Mombasa, viongozi hao wakiongozwa na naibu wa vinara Simba Arati, Abdulswamad Sharif Nasir na mwenyekiti Gladys Wanga, wameelezea kuwa katika mazungumzo hayo ODM inafaa kupewa nafasi ya mgombea mwenza wa Rais Ruto katika uchaguzi mkuu ujao. Hata hivyo, wamekashifu mrengo wa Linda Mwananchi wakiwataja kama viongozi wanaolenga kuwagawanya wafuasi wa chama cha ODM.
Tunaleta watu wetu katika mazungumzo. Tukiingia katika mazungumzo, hatuingii pale ya kuwa we are less partners. Tunaingia katika mazungumzo as equal partners. Na tukiingia katika mazungumzo tunasema deputy president, ikiwa wanalazima awe ni kule, president awe ni wa ODM. Lakini kama president ni wa UDA, deputy president atakuwa ni wa ODM.
Mimi kama deputy party leader, yale ambayo baba Raila Amolo Odinga alisimamia kwa kutetea haki za wananchi wa Pwani na Kenya mzima, mimi niko katika mstari huo. Tutasimama na tuhakikishe kwamba kazi imefanyika.
Nataka niseme ya kwamba chama cha chungwa
ni chama kikubwa na chikitaifa. Hapa Mombasa, mtu asije hapa kuwauzia uoga, asije hapa kuwauzia uongo, asije hapa kuwauzia ukabila, asije hapa kuwauzia utengamano, asije hapa kuwauzia mambo ya ukora. Mtu asikuje na mambo hayo. Sisi tunajua kama chama cha chungwa tunakaa sote pamoja na tunasonga mbele na Kenya, na hakuna mtu ataachwa nyuma.
Na mtazamaji, sasa turejee moja kwa moja kwenye mahakama ya Upeo ambapo msasa wa majaji mahakama ya Upeo unaendelea, na kwa sasa anayehojiwa ni Katwa Kigena ambaye alikuwa wakili wa Rais William Ruto. Tuendelee kutazama.
Supreme Court, will you be looking at the process more than the substance of what? Because that may go contra 159 article.
Okay, first of all, let me just answer your question directly, my lord, that I insist you cannot leapfrog. And the reason why it is necessary not to leapfrog is because it needs consideration by the Supreme Court after the other courts have considered it. You can't fly it over to the Supreme Court before the other courts have considered and applied their minds and possibly resolved it.
Yes, so sorry for engaging you. I agree, yes. But this is a matter which does not need any clarification, any further clarification. The Supreme Court has already said, if there is an issue of conflicting decisions, that's a matter of GPI. The issue is settled, it's clear. It's just a matter of taking it from the High Court to the Supreme Court and say, this is one of those you say.
Yes, my lord, but I think there are still some cures. For instance, if there are conflicting decisions, and that happened in the issue of statutory notices, they had to set up a special panel right from the High Court to the Court of Appeal before then it go to the Supreme Court. Okay, at that time there was no Supreme Court before it would go to the Court of Appeal. The issue of, the other one was the issue of arbitration. So that it is not good enough to just say, one High Court judge says this, the other High Court judge says this, so there is conflicting, let's rush. Or that one bench of the Court of Appeal says this, the other one. I think there is still that aspect of saying, let's now constitute a bench of, say, 5 or 7 judges, either the High Court or the Court of Appeal, to give it a thought before it gets to the Supreme Court. I still insist, my lord, that even in terms of policy, it would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly of those minds probably will resolve the issue and harmonize it. And if there is no agreement, it can still escalate, go over directly to the Supreme Court. As a question of jurisprudence, it's better if it just escalates.
We can hold it at that. Yes. Though to me it may not be an issue of jurisprudence, because it's an issue which is already settled it's already clear that conflicting decisions are matters of general public importance, but we can't hold it at that. Let's get to elections. We are some few months into general elections.
Yes, my lord.
And do you think, Judge, that there's a difference between general elections, fresh elections, and a runoff? Consider an issue. I believe it has not arisen yet, but it can arise. And let's take a walk to a fresh election. And let's start from a point where a petition challenging a presidential election is filed in the Supreme Court. The position which has been taken by the Supreme Court is that in the event a fresh election is called or ordered, it is only the petitioner and the president-elect who should take part in that fresh election. We are together, so that end, Judge?
Yes.
Yes. Now, let us take it this way. A petition is filed before the Supreme Court challenging the election of a president. And a candidate, an unsuccessful candidate, decides not to file a petition, but with the leave of the Supreme Court, this candidate is allowed to join in these proceedings, in this petition, as an interested party. An interested party has identifiable stake in this matter and has the right to file pleadings.
Yes.
And in these candidates' pleadings, it's stated very, very clearly that I'm in total support of this petition. The election has to be nullified, and once nullified, I am interested to take part in the fresh election. So, the position of this candidate is clear, that I want to take part. He has not acquiesced his or her position in that he has stated very, very clearly in pleadings that if it is the petition succeeds, I also want to run. But the jurisprudence which has been developed as a term is that it is only the president-elect and the petitioner. And the reasoning has been the rest of the candidates, as long as they have not shown any interest, they should not take part, which I agree. But this is a situation whereby this party who has been allowed by the court to come in as an interested party has expressly stated that its intention to run, and eventually the election is nullified and a fresh one called. Will this interested party be able to take part in that fresh election?
Thank you, my lord, for the question. We need to, okay, so your question, as is the nature of always illustrative scenarios, the question doesn't come out as to whether the petitioner is a candidate. But I want to,
the petitioner must be
and it is easier
candidate.
for me to answer the question if you don't, I don't have an answer to that question, because then we would then be looking at it and saying, what if the petitioner was not even a candidate, he's just a public interested litigant, and you are declaring that parties must go back for fresh elections. There has to be other candidates. So I would say in the scenario you've made, the candidates, so long as a person was a candidate in the elections leading to the nullification, they are eligible to participate. unless there is a specific reason why not.
Let me get to
Yes.
that, Judge.
Yes, sir.
You're saying in a fresh election,
Yes.
all candidates are eligible to take part. If I get you right, that's your position.
It depends on the nature of...
No, I limited myself
Yes.
to the position taken by the Supreme Court,
Yes.
which is a case premised on the petitioner being a candidate.
Okay.
And the court said it is only the candidate who is the petitioner and the president-elect. But now I've introduced a further element of the interested party.
Yes.
And the reason why the Supreme Court says the other candidates should not participate is they have not taken any active step in expressing their desire to run in the fresh election.
Yeah.
But this is an interested party who has said, I'm interested. I filed my paper, I support this petition. And if it goes through and a fresh election is called, I'm interested to run. So they cannot be said to have exercised their position. They have stated clearly that I need to take part in the fresh.
My Lord, I would think that if an interested party has come and said, because an interested party, first of all, is one who has a stake and will be affected by the decision.
Yes.
If he is a significant player and it's obvious that he's a significant player because from your illustration he was a candidate,
yes,
then it is my view that he is eligible to participate in the elections. Because look at a scenario where you have 5 presidential candidates, and when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the president-elect. It would be just unreasonable. It would be awkward. So I would say if somebody has come and explained himself why he did not petition, what his stakes are, what he considers to be his rights, and considering that it is a question of democracy and representation, I would take the view that an interested party who has made that expression should be allowed to participate in the elections. And I'm comforted by the fact that the point you're making has not been quite directly dealt with, being the question of whether an interested party who comes and says, I want to participate, my explanation for not having filed the petition is this, these are my stakes. To the extent that it hasn't been addressed, and being an open question, I would say my view is that if he should be allowed to participate because he has come and represented his concerns, and if he can demonstrate his case, then he should be allowed to participate.
Thank you so much.
Thank you too.
I believe that should be the position. Looking at the issue of access to justice, limiting costs, and many other parameters. Thank you for this rather long engagement. I wish you the best.
Thank you very much, ma'am.
Thank you, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, my Lord.
Good afternoon.
It's been a long day so far.
It's okay. It's okay.
Yeah, they say Kenyans know the Supreme Court to be the court that only deals with presidential petitions. So I understand why Judge Murima had to take a lot of that time. So, Judge, you did submit submissions that you have handled at the Supreme Court and High Court on matters touching land, criminal case, arbitral award, and a constitutional petition appeal, and also shared a no case to answer motion filed before the International Criminal Court. The exhibit excellent issue identification, coupled with strong ability to link facts to applicable legal principles. And looking at the ICC matter, where you submitted on the need for clarification on application of the no case to answer principle within the ICC framework vis-a-vis common law jurisdiction, I find the arguments novel, so I commend you. Have you since delivered any decision at the Court of Appeal or decisions?
Yes, I have.
Okay. I know my colleague will ask you around that. So allow me to ask you 2 questions.
Yes.
Of elections, because the Supreme Court does so many other things beside the elections which Kenyans are usually keen on. Key strength in arbitration is finality, and that is why you find most laws on arbitration clearly provide for this fundamental principle. In the New to Aggravate case, the Supreme Court was confronted with what is described as question of considerable public importance touching on the interface between arbitration and the appellate jurisdiction of the superior courts in Kenya. So what the court held is that Section 35 of the Arbitration Act is silent on whether an appeal should lie to the Court of Appeal, and this is what it held in part. Allow me to read. An appeal may be allowed in very limited circumstances where a manifestly strong decision was made. Specifically, where the High Court, in setting aside an arbitral award, has stepped outside the grounds set out in Section 35 of the Act and thereby made a decision so grave, so manifestly wrong, and which has completely closed the door of justice to either of the parties. So how would you describe the reasoning of the court by creating this exceptional circumstance vis-a-vis the general principle of finality in arbitration? Was the court trying to cure any lacuna in the Arbitration Act, or did it risk undermining the fundamental principle on limited court intervention in arbitration? Maybe you can give your explanation to your responses.
Thank you, Commissioner. Yes, indeed, in that case of New 2, my recollection of reading it is that one of the issues the court had, so the court was dealing with about 4 issues. The first one was whether the court can infer existence of an option to appeal when, I think it is Section 35 is silent, on whether a party who has gone to court for adoption of an award can appeal to the Court of Appeal. And so the question was just very directly whether, in the absence of clarity, in the absence of a direct statement on whether or not there is right of appeal or not, the Supreme Court thought that such an option to appeal could obtain. And reading that judgment, my understanding was that then the court was wrestling with a competition between 2 issues. One is the right of any litigant to a fair hearing, which is a constitutional right, and on the one hand, by the party who wants to appeal. The one party who wants to appeal saying, my rights to fair hearing have been violated, I need an opportunity to ventilate my case. Vis-a-vis the counter-arguments from the other side saying that the policy and intention of arbitration clause is to achieve finality and sooner resolution of disputes. And in some, my understanding of how the Supreme Court arrived at its decision is to balance those 2 rights. One is the right to be heard and right to challenge a situation where the decision of the High Court is so manifestly wrong on its face, vis-a-vis the desired intention of the 2 parties that there should be finality. And as a consequence of balancing those 2 interests, then the Supreme Court said that you will only appeal to the Court of Appeal where you are able to demonstrate that your situation is very distinct. It's not just the usual issues of disagreements or dissatisfaction or ordinary displeasure. You have to distinguish a very remarkable dissatisfaction with the way the High Court has dealt with the adoption of the award. And so that's why it is restricted, and that's why, to my mind, it requires leave, because that leave stage is where the court then will see if, will evaluate whether it is an ordinary displeasure or it has a very distinct legal or factual issue.
So according to it, does not in any way undermine the statutory design of that particular provision?
It doesn't undermine, and it prioritizes fair hearing and justice to all parties.
Okay, I'm satisfied with that response. And number two, the case of Mitubel Welfare Society versus Kenya Airports Authority. I know you know the facts, but what the court held is that structural interdicts are recognized reliefs in human rights litigation, and Article 23(3), sub-Article 3 of the Constitution, particularly when it comes to enforcement of social economic rights such as housing. In this particular matter, the Court of First Instance had issued structural interdict The Court of Appeal overturned the decision, saying that structural interdicts were not part of Kenya. So the Supreme Court affirmed that indeed they are applicable in Kenya. However, sometimes this year, there is the Omtata Tribunal's case, I think it was Omtata versus the National Assembly, where the court in the first instance had issued a structural interdict directing the National Assembly to come up with a tribunal's bill that had been given against Parliament, and it held that in part structural remedies must remain exceptional, proportionate, realistic, and restrained, and that judicial intervention in legislative process is justified only in the clearest of cases. So it appears there are different standards the Supreme Court has given for executive and legislature. So I would want to hear your views on whether we should maintain that the standard for judicial supervision on legislative processes should be higher than that of the executive supervision of executive compliance of court orders? And if so, what is your basis? What is your response, if it's yes or no, and give your explanation?
The Commissioner, so first of all, let me just answer the last limb of your question directly. Yes, I would think that
very comfortable. We are completely non-threatening. We just want to get the best out of you and get the best candidates for nomination for this position of a judge of Environment and Land Court. So we will start by asking you to tell us your key competencies that make you think that you distinguish yourself for nomination to the position you have applied for, a judge of ELC. We particularly want to know how you have used those competencies, your skills, your experience, your knowledge, to deal with the nature of disputes that go before the Environment and Land Court. While noting this is a very specialized court that Kenyans recommended its establishment because of the unique nature of the issues of land and environment that does not only touch on us today, but even the future generations. So we are looking for men and women of integrity, probity, knowledge, not just technical knowledge, but also socio-economic and cultural knowledge of how to really deal with those issues. So you have 5 minutes to tell us that.
Thank you, Honorable Chief Justice. I appreciate this opportunity. I've been looking forward to it, Honorable Chief Justice. Honorable Chief Justice, I'm a holder of Legum Baccalaureus from Moi University, LLB, Honorable Chief Justice. I also hold Legum Magister, LLM from University of Nairobi, Honorable Chief Justice. I'm currently doing Legum Doctor, PhD in Law at the said University of Nairobi, Honorable Chief Justice. Honorable Chief Justice, in the year 2023, I was invited as a facilitator during the training of the members of the Land Acquisition Tribunal, Honorable Chief Justice. I was invited with a mandate to train them on the mandate and jurisdiction of the Land Acquisition Tribunal arising from Part 8A of the Land Act. Honorable Chief Justice, I took them through 2 elements arising from eminent dominance, the doctrine of eminent domain on compulsory acquisition, and also took them through the rights in alieno solo, which includes easements, way leaves, and public rights of way, Honorable Chief Justice. I was invited on the understanding that I have experience on matters land. I have a hybrid experience from the academe and also from practice, Honorable Chief Justice. So I bring in the attributes of academe and also practice, Honorable Chief Justice. In the academe, you can see from my CV that I have been teaching at the university from the year 2015, and particularly for the topic today on land law, I've been teaching it since the year 2016. We are going to 10 years now. I've been teaching the land law in 2 contexts. In the context of the law at rest, which is land law itself, and the context of law in motion, which is conveyancing or proprietary transactions or land transactions, Honorable Chief Justice. I'm currently coordinating and teaching conveyancing at the Kenya School of Law. I have submitted evaluation for my students. They say that I have depth of knowledge. I can explain concepts very well, Honorable Chief Justice, and they have given me an average of 94% performance, Honorable Chief Justice. In the process of teaching land law, there is integration of environmental law because the environment has an impact on land. So we teach environmental compliance, matters of planning, including matters of zoning, which is the jurisdiction of the ELC, Honorable Chief Justice. In the practice, Honorable Chief Justice, I have 3 types of files: the yellow file, the green file, and the blue file. The green files, the yellow files are about commercial transactions. The green file are about conveyancing transactions. The blue files are about litigation files, Honorable Chief Justice. I've done various types of litigation, Honorable Chief Justice, since the year 2007. When I left the university, I've been doing it on a daily basis, whether litigation, conveyancing, or while teaching it in class, Honorable Chief Justice. 75% of those matters are land litigation. I understand land litigation, the substance of land law, because I am a teacher on the same. I also understand the procedure, the trial process, all the way to judgment, all the way to enforcement, the appellate process. One of my sample writings is submissions before the ELC. It's a live matter now pending before the Court of Appeal, Honorable Chief Justice, on matters of limitation of actions, adverse possession, and the procedure for raising the same. The yellow files, Honorable Chief Justice, is about conveyancing. I've been doing conveyancing since the year 2007 when I left the university. I understand conveyancing. Those are the matters that end up before the ELC. Simple contracts, complex contracts. I understand the repealed regime of land law. I understand the migration from the repealed regime to the current regime of Land Act and Land Registration Act. I understand the transition from the physical regime to the electronic regime of Msasa, Honorable Chief Justice. I understand the innovative ways of land ownership, timeshares, fractional shares, rates, real estate investments, trusts, Honorable Chief Justice. As said, we use conveyancing or land transactions or land practice to enforce environmental practice. Matters of compliance, matters of planning, matters of zoning, Honorable Chief Justice. And Honorable Chief Justice, I am conversant with environmental law. I'm conversant on the impact of environmental law on land, the impact of climate change on land, Honorable Chief Justice.
Now we are going to the technical area, and I will hand over to Commissioner Msasa to take up the next set of questions.
These are your legs on day 1 of Tai Chi walking. And here's what they look like after 30 days of Tai Chi walking. We start on Monday, April 27th.
If you want to be proud of your body, start Tai Chi walking before April ends to be ready for summer.
Ladies over 180 pounds. If you want to become unrecognizable by summer,
Council, sample 3 of your sample writings is an exam paper that you set for your students.
Sorry.
And I wonder why you would submit that as one of your sample writings.
Sorry, Honorable Commissioner. It's a sample assignment I did for the PhD in legal theory.
Yes. So you've attached the sample question.
Not the sample question, the answers. We did over 24 hours period.
Oh, okay.
Yeah, in legal theory.
Oh, in legal theory, yeah?
Yes, Honorable Commissioner.
Okay. Now, if a prospector for a mineral, say gold or something that can be extracted for the earth, finds that mineral in community land, what would be the process in acquiring permission to mine, and what would be the extent of the involvement of the community?
Thank you, Honorable Commissioner. When it comes to minerals, there are 2 aspects. The minerals are part of public land, but then they are on the land itself. The land, in this case, is community land. So land has to be accessed in order to get the minerals, Honorable Commissioner. The unique thing about community land is that there is a regime under the Community Land Act. You have to get permission from the Community Assembly, Honorable Commissioner, and usually you get permission from 2/3 of the community members